So as Liz mentioned, we'll be talking about good faith because it applies in every single situation in the employment relationship. So we'll introduce what that is first, and then we'll start talking about what that actually means in change processes, and then how it kind of applies to some of the problems that we've been seeing popping up in relation to COVID. COVID's definitely created more problems, or not more problems, just different problems for employers. And it's important to remember that although they are new problems and different, that good faith applies whenever you're trying to deal with them. If you'd like to, cool, thanks Adrian. It's important to also remember that good faith works both ways. So it's not only that you as an employer have an obligation of good faith to your employees, but they also have that obligation towards you as well. So what that means is that it's more than just following a process and just ticking boxes. If you could skip to the next slide. Yeah. And actually the next slide as well, Adrian.
This is my debut at running the slides, you see, so.
It means it is more than just following a process. It means that you actually have to genuinely engage with your staff and take into consideration any feedback or comments that they may have. So one of the most common breaches that we see is employers failing to provide their employees with all of the relevant information. And that applies to a bunch of different situations, ranging from disciplinary meetings through to restructures as well. But it's important to remember that in a trial period, if you are one of the employers who is still able to utilise those trial periods, that's essentially the only situation where you don't have to provide all of the relevant information to the employee. So this happens when you're thinking about decisions that impact the employee. And if you're going to do a restructure that is taking into consideration your financial situation, you do need to be prepared that you will have to provide financial reports and open your books up to people as well. Same with a disciplinary situation, you're going to have to provide all of the relevant information to your employee. What I normally do in restructures, if it's based on financial grounds, is provide like a summary of the financial information and let the employee know that they can request more, rather than kind of giving all of your profit and loss statements over to them straight away. And there is some situations where relevant information can be considered confidential. There's a very high threshold for that though, so please do check in with us if you are intending to withhold relevant information on the basis that it is confidential. So your financial affairs are probably confidential, but not to the extent where it can't be provided to your staff member. And the reason for that is that you can only withhold it if it is going to cause unreasonable harm to your commercial position. Same with confidential complaints that you might receive from an employee for a disciplinary meeting. It's unlikely that you would be able to keep that confidential complaint actually confidential. So it is a little bit tricky to kind of find the balance between those two things. This is one of the cases which has good faith breaches throughout it. It is on the more extreme end, but it just goes to show that even some of the more smaller good faith breaches, they do stack up and it becomes a significant problem for the employer. So in this case, Mr. Harris was made redundant. They had a significant number of problems with their process. It kind of started when they had 4 operating positions and they were reducing that number down to 3 operating positions. But instead of talking to all 4 employees like what they should have done, they only spoke to Mr. Harris. They targeted him for some reason. They also failed to disclose all of the information to Mr. Harris, and they claimed that that was because the information was confidential from a commercial position, but the court found that it wasn't a good reason because it didn't unreasonably harm the commercial position. In addition to those things, during one of the meetings when they were talking to Mr. Harris, the employer was quite unhelpful. They were being asked questions and they were providing very unhelpful responses and answers to Mr. Harris. And sometimes in meetings, you might get put on the spot and you might get a bit of a curveball or a question that you don't know the answer to on the top of your head. And the best thing to do is just to go back to them and say that you'll come back to them on that. But you actually do have to make sure that you do come back to them on the question. They regularly interrupted Mr. Harris in that meeting, and they appeared to be in a hurry to end that meeting as well. And the court found that the decision had actually already been made before the employer had undertaken the consultation process. So that's one of the quotes there from the judge, that he decided that it was a cynical attempt to dress up as fair what a fundamentally unfair process it was. It also, one of the interesting things about this case is that Mr. Harris had been employed by this company for 25 years, and his contractual notice period was only 2 weeks. And the judge actually commented that that contractual notice period should have been increased to take into consideration that he had been there for such a long period of time. So in this circumstance, good faith actually extended beyond what was in their employment agreement, which is quite interesting. Mr. Harris won the court case. He was awarded $12,000 compensation for hurt and humiliation, and on top of that, he was also awarded 9 months' pay plus 8% interest, which is a lot of money for any organisation. But it just goes to show that all of these fairly small good faith breaches do add up, and then you've got a significant problem on your hand. And although this is kind of one of the more extreme cases, even small good faith breaches do become problems for employers, and you'll end up getting a personal grievance, having to go to mediation if you can't settle that. So it's better to just make sure you're really confident with whatever process you're doing with your employee, whether it's disciplinary or a restructure, or just having a conversation with them about some concerns that you may have. Make sure you've got good faith at the forefront of your mind, because it will save you a lot of problems further down the track. If you could skip to the next slide, Adrian. So we've included some practical tips, because I know that good faith is a difficult kind of concept to grasp, and what does it actually mean in reality. But good faith means in reality giving notice of formal meetings to the employee, include when the meeting is going to be, what it's going to be about, who's going to be in the meeting, and why you need to have that meeting. It's really important to tell your employees who is going to be in that meeting, just to avoid them feeling like they've been ambushed. So you don't want a single employee walking into a meeting room with 3 senior managers and a lawyer, and they had no idea that all of these people were going to be in the meeting room. You need to genuinely listen to your staff member and take into consideration any feedback that they may have. It does mean sometimes, and we've seen this a lot recently with the level 3 lockdown in Auckland, is some employees don't want to hop onto a phone call or a Zoom meeting to have a conversation about a restructure or a disciplinary meeting. They're kind of digging their heels in and saying that they want to meet face to face. And if they don't have a good reason for that, if they're might be just trying to delay the process for whatever reason, it does get to a point where you can say to the employee that if they're not going to talk to you, whether that's on a phone call or a Zoom meeting, then you'll be going ahead and making a decision based on the information that you have at hand. and that's, like I said, good faith goes both ways. So they also need to be coming to the table and having a conversation with you as well, and not kind of digging their heels in unnecessarily.
Right. Okay, that's me. Thanks, Kim. Hopefully it's given everyone a bit of an insight into what's required around the general idea of what good faith involves. And I think to a large extent, it's that simple stuff that says, you know, the basic kind of principles most people run their businesses on: treat people your way you would expect to be treated in their situation, be open and honest, and sit there and talk to them about that. So now I'm just going to take people through how good faith applies in change proposals, and really why that's important at the moment is what we're seeing with the impact of COVID and other bits and pieces, that businesses and employers are looking to change how they operate. They're having to change how they operate, because either from the economic impact or the fact that you've got to move from a bricks and mortar type environment to a more of an online store. And how does that affect your employees? What we saw with the first wave of COVID when it came through was, how do we deal with all the things that government changed as well? How do we deal with the wage subsidy? How do we deal with all of these sorts of things? Can we deal with the fact that people may not want to take tests? So we'll definitely talk about all of those things as we work our way through. But as Liz pointed out in the beginning, the employment law didn't change, and there were a lot of confusing messages, and there still are, around from the government at the time about what that meant. I mean, we heard when the first wage subsidy was announced that, you know, you're going to get a wage subsidy, but people should do best endeavours to pay up to 80% of their wages. Well, so some businesses really went out there and got people involved and changed their pay to 80%. But what they missed was that the law didn't allow them to do that yet. Well, the government might have been saying one thing, the law hadn't changed. It meant you had to engage in a conversation with those people to reach their agreement about any changes to terms and conditions. So if I take you through a very high level overview of what any sort of change process would look like, I'll take you through that now. And the other aspect to really keep in mind just too is the degree of how involved you are in these sort of change proposals will really reflect the level of change or the impact it has on individuals. So the fact that you're going to change the carpet colour in the office from brown to white is a pretty small change process. You talk to them about it, you tell them it's happening next week, and if they don't like the colour, well, they can pay for a different colour in their particular part of the office. So those types of decisions, there's less sort of involved. But if it is a change to, say, change hours of work, change terms of employment, there's a more involved process, and this is probably what I'm more referring to in that. So, you know, you need to do your work before you start. Yeah, so looking at putting your proposal together, so making sure you actually outline what you're looking to do, making sure you explain to people why you're looking to do it, provide any relevant information. So Kim said earlier, if you're talking about financial situations or you're restructuring because of the financial impact, you need to be able to have that information that you have used to justify that decision, and you need to be aware that that's all potentially discoverable and should be disclosed in the process. So make sure what you are using as your information, as your basis for your decision, that it is all able to be potentially disclosed. Then think about your timeframes. How long does the employee have to consider their proposal? Do they have time to go and get independent advice? And what's the process of here? So you've mapped that out, and definitely what I've found when you're doing that, and even if it can be on a piece of paper, it can be on a presentation, whatever works for you, it's making sure you get that process down, because in your own head, as you put it down on paper, you'll see it a lot clearer, and you'll get some understanding of, oh, maybe that wasn't quite the right thing. That was what I was wanting to do, but maybe that isn't quite right. So just helping getting that documentation down, getting it written down helps in terms of tidying up the process, and you can see where any gaps are. So as it says there, don't rush it, because it is going to form the basis of how you have the rest of your conversations with people. Right. Consultation. We hear a lot about consultation, and you haven't consulted, you haven't done this, you haven't done that. But consultation, as we use in the employment context, is very much about giving people information, allowing them to comment on it, and then genuinely making an attempt to listen to it. So the process, as we said, like with any sort of change process, consultation can be as big or as long as the degree of change. I said, the carpet example is, this is my watch talking to me. The carpet example is pretty short. You don't need to worry about it. But if it's a change to, say, reducing the days of the week, or reducing one day down to 80% or 4 days out of 5, that might be a longer process. But even then, it doesn't have to be overly long. I mean, with COVID, the general criteria as a rule of thumb, there's no fixed line, is probably at least 5 working days. But we knew when COVID hit, especially in the first wave, a day or two may be completely fine. But it's making sure you've got pretty concise around your messages around your proposal to give the employee the opportunity to get some advice, provide feedback, but given the situation and the context which you made the decision and had to make the change, a shorter time period is okay. But it all depends on the facts that you've got in front of you. So the process is pretty much outlined on the screen there. Invite someone to a meeting. Initially at the initial meeting, you're running through the explanation. You may be providing information to them in some sort of letter or consultation slides or some more information that supports the what you're proposing. Give them some time to consider the feedback. You should genuinely consider that feedback. Just don't write it off. Just don't do it as a tick the box exercise, because there's been plenty of cases where the employer hasn't genuinely considered feedback. And it's not just that risk of the employer not following process. A lot of the time when I've run consultation processes, your employees who work on the front line and know your business actually come back with some ideas that you might not have thought of, and some other ways of achieving the outcome that you want. So, the best thing you can do is if you can listen to what they say and make some further changes to, I initially thought it'd be like this, but I'm changing to this because I got some good feedback that there'd be a more effective way of doing this. So really, that genuinely considering the feedback is a really important step. At the end of the day, though, you as the employer will make the decision. If you've made some further change, you may need to just reconsult, and that may be on a shorter time frame because, and say you said you were going from, you had 4 sites, you were closing to 1. Based on the feedback, you're now only closing 2. So you might just go out and say, hey, we've got some feedback, we're only going to 2. Has anyone got feedback on this before we finalise the decision? So you may go out and just get some further feedback if you think it has been a significant change to what you initially proposed. So where people are displaced or don't have a job because you've gone to less roles than you had before, you do need to be able to consider redeployment. That doesn't mean you have to do it, but you should be pretty constructive in looking to find what is the redeployment options that we have available. How do we actually look to actively give people an opportunity? It doesn't have to be on the same terms and conditions as someone is employed on. Someone who might be employed, say, as a chief financial officer, and say you weren't going to have that role in the new proposal, but you might have an accountant role. So look, this is a different role. It's not the same role as you're doing. It's not on the same terms and conditions, but you have the capability and skills to do this, or you could pick them up within a reasonable level of time. That would like to give you the opportunity to be redeployed to this role, recognising that there is a difference in what the pay or other bits and pieces might look like. They don't have to take it, but if they don't take it, then in that situation, they'd possibly be redundant. But there could be situations where there is it's just, we've got 3 people in these particular roles, we're now going to 2, so the redeployment opportunities might not be there. And so therefore, you've got to work your way through any outcomes that fall out of that. So once you've worked through that phase, it's around advising the employees of the decisions that and the next steps. And if you are considering redeployment, say like a situation where you've got 3 roles coming into 2, you should be also consulting on, this is potentially going to happen if the proposal goes ahead. Here is the criteria we're going to use to assess you through that. And this is the process of assessment that we're going to put in place for that selection. And the last phase in any sort of change process is that implementation phase. So you go through, you've made the decision as what's going to happen. Now you actually have to follow through and do it. So as everyone's pretty aware, every change in the workplace has ripple effects. And the biggest thing that Kim identified early on is really try hard to do what you say you're going to do. And if you can't, communicate that openly and early as possible. Because the other thing that happens with any change process, it's all over the show. It's a mess, it's chaotic. And what your employees will look to you for is some guidance around the process that they're going to go through. Because in the times of uncertainty and the times of stress, while you are stressed as the business owner as well, if you can provide guidance to the employees about the process that's going on, it does help mitigate that to a certain degree. Thinking in your implementation about your communication processes are critically important. So when you've made the decision, who are the people you need to talk to first? Who are the people you need to talk to subsequently? What are the communications that are going to go out to the rest of your employees? What information is going to be provided? So typically you'll talk to, when you're going through any change process that affects people and may make them redundant, is you talk to those people affected first. You give them a heads up, you tell them the decision is with, unfortunately your role will be made redundant. This is what that means for you. This is things like your notice period, if there's redundancy compensation or not, all of those things. And this is how we're going to communicate this to the rest of the business, and this is when that's going to happen. And that may be later that afternoon if you're doing a discussion in the morning. Offer things like, do you want to have the time off? And little things when we talk around good faith, it could be making sure you've invited them to that outcome meeting, advise them that they can have a support person with them, all those sorts of things. The foundation of them all is just our obligation to act in good faith. So all of those aspects, putting them all together is how you work its way through. And as I said, it'll be as big or as little as the nature of the change is on your employees. Right, now Kim's going to take us through a few questions around COVID in terms of what we're seeing come up and how that's impacting on good faith. Because from what we have observed, 90% of all the issues and problems that are coming up here are largely around good faith. And good faith, as we've tried to kind of outline, is a lot about process, making sure that you follow a fair and reasonable process in the things that you do with your employees. And that's the biggest thing, when we're dealing with disputes and other places in the authority and in the courts. 99% of the time, the problems that trip up employers are process. Very, very rarely are they for the justification part of that thing. They've got very good reasons for doing what they're doing. You just haven't dotted all the I's and crossed all the T's. All right, Kim?
Thanks, Adrian. So we've included some of the common problems that we are seeing pop up quite often, or people are getting in touch with us about. Because I know it's different challenges in the workplaces at the moment, but we do need to be keeping that good faith at the forefront of our minds. So we saw this quite often when we came out of the last lockdown, and this will be something that workplaces in Auckland will be seeing as well now that we move out of level 3 next week, hopefully, is what if my employee doesn't want to come to the workplace? There will be potentially a degree of hesitation about coming back into the workplace after they've either been working from home or just haven't been working during the lockdown, and even some hesitation about hopping on public transport in order to get to the office or the workplace, particularly now that we are seeing transmission on buses. So if an employee does come to you and says, I don't want to come into the workplace, I want to keep working from home, you should consider it, particularly if they are able to work from home and that's not going to have any impact on the work that they do. But at the end of the day, after you've engaged with your employee and you've tried to understand what their reasons are for that hesitation, if there's no good reason and it is safe to be in the workplace, then they can be required to come into work. But just be mindful about the different feelings and hesitancy and anxiety that individuals are feeling at this time, because we've definitely noticed an increased level of emotions and stress. What if the employee wants to cancel or postpone their annual leave? I've been a bit of a shocker at this over this lockdown. I've had to cancel and postpone 2 of my annual leave times and trips, but we've our employer's been quite flexible with that. But at the end of the day, if an agreement has been made about annual leave dates, there is no obligation on the employer to agree to the cancellation of those dates or the dates being changed. Particularly if in a workplace you've had to organise another individual to cover the employee's work, then you don't have to agree to it if you don't want to. But please consider it as well.
Yeah, otherwise someone will miss out on their birthday leave like Kim did.
Yeah.
And
Two trips.
Looking forward to for a long time. So, all right. The other questions we have, and a lot of them obviously around health and safety. So what if an employee comes to work with COVID-like symptoms? And there was a fair bit of debate about this with us internally. I think we landed on the fact that your health and safety obligation as an employer comes first. So that really means that as an employer, given what we know about the COVID and they've got COVID symptoms, you shouldn't be allowing them into your workplace. But you've got to sit there and talk to them about that as well. So you've got some obligations to do that. So it's when they turn up to work, you say, look, and they really want to, they might turn up because, say, they've got no sick leave, which is one of the issues that's been highlighted through things all the time. But I'll deal with that as we work our way through. But so they turn up to work, you'll have a conversation and say, hey, look, you've got COVID symptoms. Unfortunately, I can't allow you to come into the office or can't allow you to stay at work if they're there. I do need you to go home. That'll be on special paid leave at the employer's expense, because it's at the employer's direction you're doing that. And the reasons for you doing that is because you're looking after the health and safety of any other employees or visitors or clients that may be in your workplace as well. And that becomes your overriding obligation. Can you require them to take sick? Well, in those situations, they may not necessarily have been sick. They may have some symptoms. And those, if I've got a sniffly nose or watery eyes or a sore throat, could just be hay fever, which kind of brings us on to the next thing. Can you require an employee to take a COVID test? And I think in those sort of situations, if you have someone present with symptoms and you're going to send them home because you can't have them in the workplace, you can ask and you can say, look, until you have a COVID test and come back negative, I can't allow you to come back to the workplace unless you've got something from your medical practitioner, a doctor or something that says you're okay to be at work, because you have that obligation to keep the rest of your employees safe. And I think that's a really important thing. It's not, you're not necessarily giving them a choice to stay or go. The employer actually has to be the adult in the conversation and gets to say, look, sorry, I can't allow you to be in the workplace while you pose that potential risk, because then you as the employer looking after the health and safety of others. A lot of the time this isn't while I'm talking about the obligations, that's not necessarily how the conversations go. They will talk to you and say, oh look, I might have run out of sick leave, how do I get paid? And you say, well, this time the employer, you're obliged to, as the employer, pay them. So you're saying, look, go home and just be on special paid leave. It won't come off your annual leave or other entitlements. If you are actually sick after you've had a COVID test, then possibly use your sick leave until that point. Then we may want to use annual leave, or we may be eligible to apply for the leave subsidy support scheme if you fall into one of the categories there, and be able to help you through that process. And that's why being open and honest and clear in your good faith obligations is just exploring all of those options. And that's really the requirement of good faith, is to explore those options. And the last issue that we've had here, which came up through our process, is can an employer require the employee to wear a mask in the workplace? In a very short way, that is yes. But there is always a but it really depends on the circumstances that apply to your workplace. As we know, buses, for example, next week, it'll be mandatory. So it's a law, everyone will have to do it who fall into that particular category. So the bus drivers, for example, have to wear their masks at work. But an employer has a different obligation under the Health and Safety Act, which says, again, you're responsible for the health and safety of everyone in your workplace, and you also have to take all reasonable and practical steps to ensure that safety. And we're pretty clear at this point in time that the wearing of masks in places where there is a potential for risk or people passing infection it would be reasonable action to say that people can't come into there. It's a bit like any other piece of personal protective equipment, any PPE that someone would wear in the workplace where they're required to. So you say to people, and you'll have to judge it for yourselves and work with your employees to work out, does this make sense for us? You know, an office-based environment, it might be okay to say, no, you don't necessarily need to wear PPE, wear a mask in the office, but we need to be socially distanced. We need to continue to wash our hands. We need to make sure we're contact tracing for everyone in the office, as we're all required to do. So those other health and safety obligations are still there. But some office spaces might say, look, given the nature of what we do and how much we interact and talk and physically close to each other, or even just passing others in the workplace, we are going to make it mandatory to wear masks. Because the other part that we talked about, people got COVID, if one person bring it in, as we saw with Americold, it shut down the entire operation, and therefore you're stuck as the owner or the business person running the business, having to continue to have all costs in terms of running your business, but none of the revenue because you can't actually operate. And that would be not an outcome anyone really wants. So those are the sorts of problems that we are seeing come up very much in terms of COVID. What would I like to do from there? So look, you know, really those three key points to remember. Good faith is required in all aspects of employment. It doesn't change in the COVID world. And that's probably what we've seen with a couple of cases in particular, the Dove Hospice case and the Solly's Transport case, which came up. They've only been to the authority yet, but believe me, there are plenty of other cases in the works that is slowly working their way through the justice system about where either employees, employers, or unions are having disputes about what was done or has been done as a result of people making decisions to change during times of COVID. So the Solly's Transport case, where there was a couple of employees who got made redundant. Initially, the business went out and said, hey, we're going to apply for the wage subsidy, chose not to apply for the wage subsidy for these two individuals, and then made them redundant without any real conversation further than what was just said. Strangely enough, they didn't meet any of their obligations around good faith of talking to those people about what was being proposed, giving them an opportunity to comment, and then communicating the final decision, allowing them to get advice, all of those sort of things. None of that was done. So I think the awards were roughly in the realms of about $25,000, $30,000 each in terms of compensation, some fines for the business for not breaching the Act in terms of its good faith obligations, and obviously the costs of having to spend your time as a day or two either in mediation and then before the Employment Relations Authority. That would have cost roughly around the $25,000 mark as well. So it becomes an incredibly expensive exercise, time consuming, worrying and stressful for a business, and could be avoided if you start to work together a bit more with your employees. The last part around good faith, it is actually something genuine and real. It's not something that it's not a tick box exercise. The tick box might be there in terms of the process, but you've got to make a genuine and real attempt to make sure you're considering the different aspects of it.